I have written a series of letters to a variety of people, stopping with President Bush, and gotten absolutely little response. This is a letter, the first of a series, to the governor of the great state of Florida, where the criminal activity is primarily occurring. It's to the office of the governor, Honorable Charles J. Crist, Jr. I will discuss the letter along the way and try to make it clear by which way I'm talking as to whether or not it's in the letter or whether or not it's a comment. Okay, Dear Governor Crist, in this, the first of many letters to you, a quote from many of my recent letters to President Bush. Your administration's performance was noted by the Florida Bar in a Florida Supreme Court case hearing this week, where their lawyer representative was heard to speak a statement to the effect that these civil rights laws do not apply to judges. The lawyer actually said very softly, as though she didn't believe it herself. Remarkably, this lawyer was from a minority. Your Attorney General and Presidential Counsel allowed this pathetic, un-American belief to endure. Your Presidential Counsel is now your, and unfortunately, America's new Attorney General. The second one of the administration. This false claim is now the law of the case for one case within the highest court of Florida. Respondent's argument clearly demonstrates his failure to understand that the right to be heard is not limited to only being heard in person. The right is preserved by permitting a party to submit his or her position in writing. Right to be heard is a right to submit? Extract from paragraph 72 of the report of referee. This claim of trial and hearings in secret is constitutional blasphemy, cultured by the Supreme Court of Florida. Lift up this unholy, putrid rock. The U.S. DOJ would find criminal actions to cover up the admitted, stated in paragraph 72, judicial actions which intentionally violated fundamental rights to be heard at all hearings of any import in person, and not heard by later reading, before or after the verdict. In fact, the reality of the situation was he interrupted the moving party because he wanted to get his day done and make his ruling before he heard the evidence, because he knew that he was fixing the case, and he was, I guess, a little emotionally distressed. That's my best guess. Someone told me it was a matter that there were 7 or 8 lawyers in the room, local lawyers mainly, and he didn't want to lose face by hearing the evidence first before he made the putrid ruling. I don't know. All I know is he ultimately never signed the final ruling. He was supposed to by law, but he ducked and elected to have the hearing held one more time and have a judge do a different version of what he did. So it's a little hard to understand what's going on there. But I think they're all aware that what they're doing is wrong, that we're not Alice in Wonderland, where it's first the verdict, then the trial. That's what the Queen of Hearts said. We should have no Queens of Hearts in our courtrooms. We don't want to hear the evidence before they get to the verdict. You can't do that without violating the right to be heard. And if it's over something of some importance, like property rights or your family rights, you definitely have stepped upon sacred ground. Continuing the letter. I ask that you answer why judicial and other misdeeds have been stonewalled by the office of the Florida Attorney General, by your predecessor, John Ellis, Jeb Bush, and by his predecessor, Lawton Childs. First, communicate if you care to violate a Democrat-Republican stonewall. As stated 1 week ago in your inaugural address, your government will communicate in clear, plain language. I provided the "your" and the "will," but he was going to require them to. Since I have sincere doubts that you dare to communicate on this, I again attempt to interest Presidential Denver, this year's 2008 edition, and others into living up to their oaths of office to defend the U.S. Constitution, of which has been made a mockery, not just by the idiotic claims in red above, but so much more. And anyone may write for details, including you. Sincerely, investigate the corrupt, with dots in between the words, @gmail.com is my address. My name shall be omitted from public for the moment. I maintain my right to privacy until it changes. Copies to Senator Hillary Clinton at her office 476, Senator John McCain at 241 Russell Center Office Building, Senator Barak Obama, who has not received any yet, The other two have, and they have nothing to say, at 713 Hart Senate Office Building, and Representative Walter B. Jones at the Rayburn Building at his address, 2333, because he at least stood up on one matter, Mr. Nifong, correctly, I believe. And this will be posted in HTML form or JPEG form, extracted, wherever possible on the internet, trying my best to maintain my privacy until it finally doesn't matter. At this point, it does matter. This is a strategy trying to embarrass Democrats and Republicans. Every one of them that holds political office should be bothered by the fact that they have protected corrupt judges since at least 1999, maybe before. I know of 30 separate attempts to get the attention of the state Democrats and state Republicans hand-delivered to their offices over and over again, and not a one of them wanted to talk. How do you make your state representatives be rendered mute and unable to speak? Totally speechless, that is? How can they be rendered totally speechless? Ask them to go after corrupt officials that they know they're supposed to protect. It's sick that they failed to do anything. It's sick they didn't ask a question. It will be sick when he does not communicate. But I'll let you know.